Agriculture and Food.
1310, an act to strengthen the Internal Affairs Service of the Philippine National Police, amending for the purpose certain provisions of Republic Act number 6975 as amended by Republic Act number 8551, and for other purposes, Senator Lacson.
To the Committees on Public Order and Dangerous Drugs and Finance.
Communications letters from Bangko Sentral ng Pilipinas transmitting to the Senate copies of the following certified and authenticated BSP issuances in compliance with Section 15A of Republic Act number 7653, Memorandum number M-2017-001 dated 17 January 2017, Circular Letter number CL-2017-005 dated 20 January 2017, and circular numbers 940, 941, and Lacson, Ligada, Pacquiao, Pangilinan, Po, Recto, Soto, Trillanes, Villanueva, Villar, Sovereign, Senate President Pimentel.
With 19 senators present, the Chair declares the presence of a quorum. Majority Leader.
Mr. President, I move to dispense with the reading of the journal of the 56th session, Tuesday, January 31, and consider the same as approved.
Is there any objection to the motion? There being none, the motion is approved, and we dispense with the reading of the journal of the 56th session and consider the same as approved.
Mr. President, we'd like to acknowledge the guests of the Senate and the gallery. We have Mayor Marisa Red Martinez of Santa Cruz, Marinduque, guests of Senator Legarda, former Mayor Raymond Apasible, and former Mayor Charito Apasible, former Congressman Dong Apasible of Nasugbu, Batangas, old friends, and also the officers of the Lady Local Legislators League of the Philippines, headed by the new Executive Vice President, the Vice Governor of Laguna, Vice Governor Karen Agapay, and also University of Santo Tomas Master of Law students, Attorney Albano, Gomez, Judge Grimales, and they're headed by Attorney Morales. I'd like to welcome them to the Senate, Mr. President.
Welcome to the Senate to all of our guests.
Mr. President, I move that we proceed with the reference of business.
Is there any objection? There being none, the motion is approved. Secretary, let us do the reference of business.
Bills on first reading. 1308, an act institutionalizing reforms in the procurement by distribution utilities of supply for the captive market. Senator Win Gatchalian.
Referred to the Committee on Energy.
1309, an act strengthening sustainable agriculture and enhancing support for small organic farmers, amending for the purpose certain sections of Republic Act number 10068 or the Organic Agriculture Act of 2010, Senator Grace Poe.
The Committee on Agriculture and Food.
1310, an act to strengthen the Internal Affairs Service of the Philippine National Police, amending for the purpose certain provisions of Republic Act number 6975 as amended by Republic Act number 8551, and for other purposes, Senator Lacson.
To the Committees on Public Order and Dangerous Drugs and Finance.
Communications letters from Bangko Sentral ng Pilipinas transmitting to the Senate copies of the following certified and authenticated BSP issuances in compliance with Section 15A of Republic Act number 7653, Memorandum number M-2017-001 dated 17 January 2017, Circular Letter number CL-2017-005 dated 20 January 2017, and circular numbers 940, 941, and 942 dated 20 January 2017.
To the Committee on Banks, Financial Institutions, and Currencies. Majority Leader.
Mr. President, I move that we transfer from the calendar for ordinary business to the calendar of special order, Senate Bill 1108, under Committee Report number 32.
Is there any objection to the motion? There being none, the said measure is so transferred.
The permission of the Chamber, I move to consider Senate Bill 1108 under Committee Report number 32.
Is there any objection? Senate Bill number 1108 under Committee Report number 32 is under consideration.
May we ask Secretary to read the title of the measure?
An act identifying other persons criminally liable for election offenses and increasing the penalties for election-related offenses, amending sections 263 and 264 of Batas Pambansa Bilang 881 as amended of the Omnibus Election Code of the Philippines, and section 46 of Republic Act number 8189 or the Voters Registration Act of 1996 and for other purposes.
Mr. President, to sponsor the measure, may we ask the Chairman of the Committee on Electoral Reforms and People's Participation, Senator Laila de Lima, be recognized.
Is there any objection? But before recognizing the good senator, we will have a series of speeches, so the chair requests for silence and your attention to the speakers. So Senator de Lima is recognized.
Thank you, Mr. President, distinguished colleagues. It is my honor as chairperson of the Committee on Electoral Reform and People's Participation to report back to you that Senate Bill number 1108 has been considered, studied, and publicly heard. After taking into account the inputs of the Commission on Elections and other stakeholders, we are now recommending that Senate Bill number 1108, introduced by Senator Joseph Victor G. Ejercito, be approved with amendments. Before I joined public service, I was an election lawyer, advocating for clean and honest elections. Advancing then the interests of my clients, I made sure that no mockery of the election process would take place and that they do not become victims of election cheating or violence. As an election lawyer, I served a number of governors, vice governors, congressmen, congresswomen, mayors, vice mayors, councilors, and even barangay chairmen. I am honored to have served as an election lawyer to the likes of then Senator Raul Roco, then Senate President Manny Villar, and now Senate President Coco Pimentel. Incidentally, Senator Pimentel's case was an eye-opener on the intensity and gravity of the electoral fraud and irregularities that transpired in the 2007 national and local elections. In the end, over 300,000 fake ballots were found to have been included in the tally of the elections, and which were consequently invalidated by the Senate Electoral Tribunal in its 2011 decision of that protest case. I also served as the election lawyer of Senator Alan Peter Cayetano, who, during the 2007 elections, was not a favorite of Malacanang, so to speak. Yes, I advocated for Senator Alan Peter at a time when the might of the entire administration was bearing heavily down on him. Fighting for truth and justice, I believed then that it was unfair and unjust if he was deprived of the chance to serve the public as senator simply because he was critical of the Arroyo administration. Mr. President, it is exactly because of my experience as an election lawyer that I understand the need for the imposition of stricter penalties for the commission of election offenses, stricter than those already provided for in Batas Pambansa Bilang 881 or the Omnibus Election Code of the Philippines and Republic Act number 8189 or the Voters Registration Act of 1996. Indeed, the idea of being imprisoned for 6 years and 1 day, but not more than 12 years, as proposed to be increased from the current imposable penalty of only 1 year to not more than 6 years for the commission of an election offense, would be a deterrent against the perpetration of electoral fraud or irregularities. Aside from the singular increase in the penalty for the commission of election offenses, this prospective law that seeks to amend the Omnibus Election Code and RA 8189 also provides for the following. Number one, if the offender is an officer or employee of the COMELEC, the AFP, the PNP, or any other security force, including paramilitary units, he shall be punished with a maximum penalty of 12 years. 2. If the election offense is committed through and attended by violence, coercion, intimidation, force, or threats, the guilty offender shall suffer a higher penalty of imprisonment of 12 years and 1 day at the minimum, up to 20 years at the maximum. 3. The political party, coalition, or party list to which the guilty offender belongs shall be penalized with a fine of not less than 500,000 pesos, increased from the current 10,000 pesos as part of the civil liability incurred for the commission of the election offense. Number 4, in case of a prisoner illegally released from any penitentiary or jail, the director of prisons, provincial warden, keeper of the jail or prison, or persons are required by law to keep said prisoner in their custody, and the subject prisoner shall suffer the penalty of reclusion perpetua if the prisoner illegally released commits any act of intimidation, terrorism, or interference in the election. 5. For violations of prohibited acts under RA 8189 or the Voters Registration Act, the same increase in penalties shall apply, including the graver penalties when committed with and attended by violence, coercion, intimidation, force, or threats, or when committed by an officer or employee of the COMELEC, the AFP, the PNP, or any other security force, including paramilitary units. 6. If a felony penalized under the revised penal code is committed in connection with an election or political exercise, the election-related element shall be appreciated as an aggravating circumstance in the commission of said felony. And number 7, if the commission of the election offense likewise constitutes a felony under the revised penal code, the offender shall be prosecuted separately and concurrently under the Omnibus Election Code and the revised penal code. And perhaps most significantly, Mr. President, these proposed amendments will ensure higher success rates in the prosecution of such offenses, considering that these higher penalties will qualify potential witnesses to avail of the benefits of Republic Act number 6981 or the Witness Protection, Security, and Benefit Act, which under Section 3, Paragraph A of said law, as it currently stands, requires that, quote, the offense in which the witness testimony will be used is a grave felony as defined under the revised penal code or its equivalent under special laws, unquote. The proposed increase in the penalty would precisely make it a grave felony and therefore qualified under the WPP of any witness to avail of the benefits thereunder. All these are imperative amendments to our existing body of election laws because our electoral process is sacred. It is the cornerstone of democracy itself. Severe as it may seem, the gravity of the penalties in the proposed bill is commensurate to the crime committed, especially for COMELEC officials and government security forces, since they are the ones responsible of ensuring a free, orderly, honest, peaceful, and credible elections. This bill, therefore, pushes further against the culture of corruption and bantay salakay in our electoral processes, against the practice of the guardians becoming the culprits of fraud and cheating. Admittedly, increasing penalties alone will not solve the problem of cheating in our electoral system. So long as only a few are prosecuted and jailed, and that is a reality now, election officials will continue to be corrupt adopted by candidates and their election operators. This is why the Committee on Electoral Reforms and People's Participation has lined up a series of bills proposed by our distinguished colleagues in this august chamber, measures that will in totality contribute to ensure effective election law enforcement, if not introduce an overhaul in the way we conduct our elections, including the reform of the political party system, the enactment of an anti-political dynasty law, and a reconfiguration of election campaign financing towards the democratization of the donors base and transparency on large campaign financiers. Needless to say, this proposed bill is but a first step towards what we envision as a modernized political party and electoral system geared towards greater public participation in the essential exercise of the people's political right to determine the future they want for themselves. But first, we must start with the basics of remedying the anomaly in our antiquated election laws by putting more teeth on the penalties that were formulated long ago in a milieu and an era very different from our own. From manual elections, we have shifted to automated elections, thus also shifting forms of election cheating from vote padding and vote shaving during the canvassing process to pre-election day election violations on campaign propaganda, as well as massive vote buying. Ang biro po ngayon ay imbes na sa mga abogado at operator na nagbubuhos ng perang pandaya, ay inuubos na lang sa vote buying ang pera ng mga kandidato. Totoo man ito o hindi, ang punto ay nag-iba na ang kalakaran sa larangan ng ating halalan, kasama na dito ang mga pamamaraan sa pandaraya. Ang sagot natin dito ay ang walang tigil na pagrepaso ng ating mga batas para umakma sa umiiral na realidad ng ating panahon. Kung nasaan ang kalapastangan sa pandaraya, doon tayo dapat matunton ng sambayanan, nag-uusisa at umuusig sa mga natitira pang mga politiko na hindi naniniwala sa pamamaraan ng demokrasya, ngunit sa kabila ay natutuwa pang umupo sa posisyon na nakamit sa pamamagitan ng pandaraya at pagnakaw sa hatol ng sambayanan. Tapusin na po natin ang ganitong uri ng politika at mga ganitong uri ng mga politiko. Ngunit sa kasalukuyan, dagdagan muna natin ang taon ng pagbilanggo sa mga mandaraya, opisyal man ng gobyerno o kandidato, para mabulok naman ang kanilang kampon sa bilangguan at subukan nilang doon tumakbo bilang mga gang leader na mga katulad nilang mga pusakal. Dahil mas malala pa ang kanilang kasalanan sa bayan bilang mga naturing na magnanakaw, pumapatay at gumagahasa sa ating demokrasya. In the words of Senator Ejercito, the author of the bill, quote, "It is of vital importance to ensure that election results represent the sovereign will of the people and not manipulated by individuals who desire the seat of power to protect their personal interests," end of quote. We must stand against unscrupulous individuals who allow themselves to be conspirators in the travesty of the electoral process. In light of the foregoing, I hereby appeal to my colleagues to lend their support for these imperative amendments to our body of election laws. Marami pong salamat.
Thank you, Senator De Lima. Majority Leader.
Thank you, Mr. President. Senator J.B. Ejercito wishes to co-sponsor the Senate Bill 1108, but he will deliver it on Monday, Mr. President. So in the meantime, to give the other senators time to study the bill, I move to suspend consideration of Senate Bill 1108 under Committee Report number 32.
Is there any objection? There being none, consideration of Senate Bill number 1108 is hereby suspended.
Mr. President, well, for propriety's sake, I just want to inform some of our guests in the gallery that I was given a list of those we would like to acknowledge, but I would wish that the senators submit the names of their guests before the order of business, because once we're in the order of business, it's not proper for me to greet some of the guests here in the gallery. This is not a television show, Mr. President. started. So forgive me, but I don't think I should do that. Anyway, with the permission of the body, I move to consider Senate Bill 1305 under Committee Report number 29.
Is there any objection? Majority Leader, Senator Gordon is taking the position. What's the pleasure of the
Just a little matter of housekeeping, Mr. President. I would appreciate it very much when somebody sponsors a bill here that we are given a copy of the bill. I do not have a copy of the bill, and neither has Senator Binay. It would be more cogent, more logical, and more speedy if we get a copy before anybody stands up and sponsors a measure. Housekeeping lang po yan.
The suggestion is noted. So we go back to the pending motion. Is there any objection? There being none, the motion is approved.
Mr. President, last week we started with the sponsorship of Senate Bill 1305, which is now on the table. However, we still have more senators who intend to deliver their co-sponsorship speeches on the matter or in the measure. May we now therefore move to recognize Senator Nancy Binay for her co-sponsorship speech. Thereafter, Senator Lauren Legarda will likewise deliver her co-sponsorship speech.
For the information of everyone, we are tackling Senate Bill number 1305. Can we proceed? Secretariat, please make sure those who need a copy should be given a copy. Is there any objection to the motion to recognize Senator Binay? There being none, Senator Binay is recognized to co-sponsor the measure.
Mr. President, bilang isang ina, alam ko kung gaano kahirap mag-alaga ng anak habang naghihintay na maghilom ang sugat sa panganganak. Having 4 children, I was lucky that I was not required to immediately return to work, but for majority of Filipino mothers, resting for an indefinite amount of time is a luxury that they cannot afford to do so. That is why it is imperative that we, my colleagues in Congress, must work together and pass the proposed increase in maternity leave benefits from the existing 60 days to 120 days. Para sa aming mga kababaihan, kulang na kulang ang 60 days na maternity leave, lalo na kung maselang ang pagbubuntis at panganganak. Karamihan din sa mga nanay ay pinipiling magtrabaho 2 o 3 linggo bago manganak. Ito ay upang magamit ng husto ang natitirang 5 o 6 na linggong maternity leave sa pag-aalaga sa kanilang anak at sarili. Mr. President, being a mother is a wonderful experience, and no words can fully describe the feeling of being with my children. Studies have shown that a longer rate of mother-child bonding, especially through breastfeeding, has long-term effects to the child's development and health. So it pains me to see a mother cutting short the time to bond with her child and go back to work, especially during a crucial period of the infant's development. Some countries in Europe have recognized that mother and child bonding deserve a longer time and allowed a year with pay for them. Even the International Labor Organization recognizes a longer standard of 98 days. Our country even falls short of the ASEAN coverage of 93 days of maternity leaves. It is high time that we in the Philippines recognize the need and allow for a longer time for a mother to spend with her child. It is also high time that we recognize the role of a solo parent in raising her child. It is only just that we add another 30 days to their maternity leave benefits. It is hard enough to raise a child with 2 parents, and I can only guess the effort for a solo parent. Sabi nila, it takes a community to raise a child, kung kaya't marapat lamang na gawin natin ito sa Kongreso. Bilang bahagi ng mas malaking komunidad, ang ating tungkulin na pangalagaan ng buhay at kalusugan ng ating mga anak ang susunod na henerasyon. So I urge my colleagues in Congress, let us pass Senate Bill number 1305. Maraming salamat po.
Thank you, Senator Binay. Majority Leader?
May we now recognize Senator Lauren Legarda to deliver her co-sponsorship speech.
Is there any objection? There being none, Senator Legarda is hereby recognized.
Mr. President, Article 13, Section 14 of the 1987 Constitution provides that the state shall protect working women by providing safe and healthful working conditions, taking into consideration their maternal functions. It is in this light that I lend my support and co-sponsor the proposed expanded maternity leave law. This landmark measure aims to increase the maternity leave of female employees in both the public and private sector, and thus fully comply with international labor standards on maternal protection, which recommends a minimum of 98 days of maternity leave. Under the said measure, the number of days of paid maternity leave shall be raised to 120 days for all workers, whether private or public sector employees, with the option to extend for an additional 30 days without pay. Moreover, in the case of solo parents who qualify under the Republic Act 8972 or the Solo Parents Welfare Act, the paid maternity leave shall be for 150 days. This is a multi-pronged measure aimed at improving maternal health care, reducing child mortality, and promoting breastfeeding. It is also an important women empowerment measure because when mothers are given enough time to recuperate from childbirth and care for their newborns, they feel more fulfilled as mothers, which will definitely affect their emotional well-being, give them more confidence, and allow them to be prepared again to embark on a more challenging role of being working mothers and equal partners of men in nation building. For these reasons, I urge my colleagues to lend their valuable support so we can ensure the swift passage of this measure. Thank you, Mr. President.
Thank you, Senator Legarda.
With that, Mr. President, I move to suspend consideration of Senate Bill 1305 under Committee Report number 29.
Is there an objection? There being none, the motion is approved.
Mr. President, I move to resume consideration of Senate Bill 1306 under Committee Report number 31.
Is there any objection? There being none, Senate Bill number 1306 under Committee Report number 31 is, the consideration thereof is hereby resumed.
Mr. President, this is the measure creating the Philippine Boxing Commission. The parliamentary status of the measure is that we are in the period of interpellation. So I move to recognize the sponsor, Chairman of the Committee on Sports, Senator Manny Pacquiao, and to interpellate Senator Zubiri.
Is there an objection? Senator Pacquiao's sponsor is recognized, and Senator Subiri to interpolate is recognized.
Thank you, Mr. President. Mr. President, this being a friendly interpellation to my kababayan, our colleague from Mindanao, Senator Manny Pacquiao. We all know, Mr. President, that the honorable sponsor is an expert in the field of boxing, being that his whole life was dedicated to the sport, and that if there's anyone in this chamber that has a full knowledge of this proposal, Mr. President, is the gentleman from Sarangani. I'd just like to ask the sponsor, what is the purpose of creating a boxing commission, Mr. President? The whole purpose, because right now we have the GAB, if I'm not mistaken, the Games and Amusements Board. What is the purpose of creating this other agency, Mr. President?
Thank you, Mr. President, for this opportunity to explain the purpose of this bill. The purpose of this bill is to strengthen the boxing industry in our country, to protect the boxers. We know that boxing is not an easy sport, so that's the main purpose of this bill, Mr. President.
So really to strengthen the boxing industry, Mr. President, because I know for a fact after lengthy conversations with the honorable sponsor last week, I happened to mention to him that our region of Mindanao are boxing crazed people. They love boxing. Pati sa fiesta, araw, may boxing yun. Amateur boxing, professional boxing, nakapanood pa nga ako na transgender boxing. Diba? Kasi ano tayo, we're LGBT friendly. So pati boxing, meron transgender boxing. I've seen it in my province. Quite interesting. So, I agree with the sponsor, Mr. President, that we need a commission that is focused on this sport of boxing, which is loved by our people all over the country, from Apari to Holo, Mr. President. But I noticed, Mr. President, in the bill, and I'll be short about this because I really want this measure to pass for our Filipino boxers. But I noticed in the measure, Mr. President, that the compensation is only 8,000 pesos, I believe, for the members of the board. It's a very small amount for the chairman's salary. Is this practical, Mr. President? I'd like to ask the sponsor if this is practical.
Mr. President, that's not a problem with me. We can increase the allowance or salary of the chairman if that possible. Anytime we can increase it, and also the board members on board.
So, Mr. President, before I end my interpellation and support of the measure, I'd like to acknowledge in the gallery two of our world champions and famous boxers who's brought honor to our country. Jerry Peñalosa and Onyok Velasco is here in the gallery right now, Mr. President. And it's been a joy and pleasure to watch them fight for our country. I'm sure they're here today to support the measure of the good gentleman from Sarangani. That's all, Mr. President. I don't have any further questions for the sponsor. Thank you, Mr. President.
Thank you. Mr. President, may we recognize the President Pro Tem, Senator Franklin Drilon, to interpolate.
Senator Drilon is recognized.
Thank you, Mr. President. At the outset, let us state on record that we are supporting this measure, and we congratulate Senator Pacquiao for having taken the initiative of crafting this measure and submitting it for the consideration of the chamber. So it is in that sense, Mr. President, that we ask the gentleman from Sarangani and General Santos to yield the floor for a few questions.
It's my pleasure, Mr. President.
Mr. President, as we said, this is a laudable measure, and the gentleman from Sarangani has stated and has spread into the record the purpose of this measure. Mr. President, first, what is the present setup that we propose to change with this measure?
The present setup is, Mr. President, is like I said, strengthening the boxing industry, and also not only that, but also utilize the sport as a source of revenue, and also to make sure that our boxers will handled and has protection for any accident. We know that boxing is very is a difficult sport.
Ang ating pong tinatanong, ano po ang pagkakaiba noong Philippine Boxing Commission na ating ibig ibuo sa pamamagitan ng ano ba sa ngayon? Sino ba ang governing body?
The governing body, Mr. President, is the GAB, Games and Amusement Board. But GAB is handling all sports. I mean, everything, gambling, sports, and I want to basketball in sports, and I want to create this boxing commission for the purposes to protect the boxers and focus only in boxing, just to protect them and give them proper protection.
Should we not also protect the other athletes? For example, we have provided for benefit share. Yung ibang atleta po, hindi ba pwedeng dapat isama rin dito?
Pwede rin man po, pero ito ay exclusive lamang para sa boxing industry. We know that in boxing, yan lang ang tanging paraan natin na, one of the sports na pwede tayong magipag-compete all over the world.
Sa ating saligang batas po, mayroong prinsipyong dapat pantay-pantay tayo lahat, or equal protection of the law. At hindi po pwede na sabihin natin ang isang atleta ay ibubukod at bigyan ng special attention, at yung ibang atleta similarly situated ay walang protection. Meron po tayong equal protection of the law na nakalagay po sa ating saligang batas, specifically sa ating Bill of Rights. Nakalagay po, no person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the laws. Ang ating po, nababahala po ako na kung sabihin natin ang boxer lamang ang entitled dito sa mga benepisyo at dapat bigyan ng proteksyon, baka po lumabag sa ating saligang batas dahil wala po tayong binibigay na proteksyon at benepisyo doon sa ibang atleta. Yun po ang prinsipyo na dapat natin talakayin. At itong prinsipyo ito ay isang sangayon po sa ating saligang batas at pwede pong kasabi na maging ang konstitusyon ng batas natin kung exclusively para lamang sa athletes. I'm sorry, sa boxer.
Ito po ay unang hakbang lamang, dahil especially I'm a boxer. Unang hakbang lamang to, hindi lamang kumbaga, I'm not saying that this is only for boxing, but I'm thinking about other sports. Hindi lang pero hindi tayo makakausad kung hindi natin umpisahan. So saan tayo mag-umpisa dito sa boxing? If we can after this, if we can do something for another sports like basketball or tennis or anything, pwede po rin po tayong gumawa din ng hakbang ng bill para po sa kanila. Pero sa ngayon, itong boxing muna ang naisip ko na i-create. And after that, pwede namang mag-create din ng ibang commission din para din sa mga ibang atleta na hindi lamang boxing.
Very laudable, Mr. President, except that our Constitution provides for the equal protection at dapat lahat po na atleta na similarly situated ay dapat makasama dito sa panukalang batas. Halimbawa po, si Hedelin Diaz, bakit po hindi kasama sa weightlifting? Bakit po sila hindi kasama dito yung weightlifters?
Ito po ay boxing lamang.
Kaya nga po, boxing lamang. Ang sinasabi ko, bakit hindi natin isama ang ibang athletes? Dahilan po sa ating saligang batas, dapat lahat po pantay-pantay tayo or equal protection of the law. At kung may benepisyo po para sa boxer at importante po ang benepisyo para sa boxer, dapat yung ibang athletes din natin ay dapat mabigyan ng benepisyo at hindi po pwedeng sasabihin natin umpisa lang yan. Kaya lahat po ay dapat pag-isipan din natin yung sila Efren Bata Reyes. Bakit hindi sa World Pole Champions dito? Sila Francisco Bustamante, si Renato Alcano, si Dennis Urculio, yung mga track and field legends po natin, kagaya ni Lydia De Vega, si Elma Moros. Bakit po hindi sila sakop dito sa benepisyo nito?
Under po sila ng GAB at tiwala naman tayo sa GAB na pinapatupad nila yung tama, pero ito kasing boxing na sinasabi natin is napakadelikado na sports, no? Sa aking pagbuboxing, makita ninyo ako, buhay ako dito, pero ilan ang kasama ko na namatay sa larangan ng boxing. Since then, so
yun pong martial arts, ganun din, hindi po ba? Yung martial arts, mayroon ding danger yan sa life and limb of the athlete. Siya ba hindi kasama rito?
lahat po ng sports na yan ay under ng yung mga binabanggit nyo is nasa sa Games and Amusement Board.
Oo nga, pero yung mga boxers, ganun din under din sila ng Games and Amusement. Bakit sila hinihiwalay?
Yes, Mr. President, under sila ng Games and Amusement Board, but like I said, na ito ay mahirap na isa sa pinakamahirap na sports at pinakadelikado dahil marami pong namamatay pag hindi maganda at naayos at protektado sila sa namamahala nito.
Sa ngayon po kami dyan na talaga po mahirap ang sports na ito. In fact, we congratulate the good sponsor for having achieved so much and having brought honor to our country. But here we are talking about the equal protection. Yung pantay-pantay po dapat tayo sa ilalim ng batas. Yun po ang prinsipyo sa ating saligang batas. Kaya siguro yung mga kung ano man ang panganib na hinaharap ng isang boxer, ganun din ang panganib na hinaharap ng isang martial arts athlete. Hindi po ba? O judo, ganun din po.
Mr. President, with the permission of you two gentlemen, may I offer an interjection, Mr. President? With the permission. Yes, Mr. President, the other sports, amateur sports, have a commission, the Philippine Sports Commission. The boxing is a very peculiar situation. It is the only sport wherein there is a amateur and professional in one. And that is their problem with the Games and Amusement Board, Mr. President. The GAB is only for professional boxing. And so I think that is the reason that this commission is being created, Mr. President, to give that. And besides, there is indeed the fact that the boxing is only one of the very few sports where the Filipino will excel worldwide, Mr. President.
Thank you, Mr. President. But let me reiterate that under our system, under our Constitution, the standard is there should be no material difference between the classifications. I'm sorry, I take that back. In order to have a valid classification, there must be a material difference between one and the other situation. Halimbawa po, yun pong boxing at saka professional combat sport like martial arts. Mixed martial arts.
MMA.
Yeah, the mixed martial arts. Pareho po ang risk involved between a mixed martial art and a boxer. And therefore, we cannot validly make a class of the boxer without including the mixed martial arts athlete. Otherwise, you suffer from a constitutional infirmity of the equal protection of the law being violated. Pareho po yan. Ang prinsipyo po ng ating Bill of Rights, kung those who are of the same class must be treated similarly. And we are saying that maybe the others, yung mga athletes, hindi, there can be a valid classification. But insofar as professional combat sport is concerned, wala pong valid distinction that we can think of in order to exclude the professional, combat sports. That is the basis of the classification under the law and under the Constitution, Mr. President.
Mr. President, perhaps let's find out if Senator Pacquiao can answer my question of whether mixed martial arts is recognized by the Philippine Sports Commission or by the general the GAB. I know that it is not it's not part of the program of the Philippine Sports Commission. It does not have a national body governing it, so it's completely different. While in the case of boxing, if we're talking of equal protection, boxing is not equally protected right now because the Philippine Sports Commission is only on amateur sports and does not have anything to do with professional sports. And boxing is a premier professional sport, Mr. President. That is the difference. So perhaps we can try to find the middle ground on the point being raised by the President Pro Tem so that we can solve that predicament. Based on the perspective that he is putting forth, Mr. President.
MMA and full contact sports is a relatively new sport, and it is still unregulated in the Philippines. So we're pointing out a possible loophole in our present laws right now. Depends on the hearing or the research of Senator Pacquiao.
Mr. President, bago lang kasi ang MMA tsaka itong Taekwondo.
UFC, etc.
Ay, UFC, bago lang po yan. Boxing, yan ang boxing is...
Unfortunately, Mr. President, the principle of equal protection of the law does not take into account whether or not a sport is new or it is old. That would not be a reasonable classification of boxing as a sport distinct from mixed martial arts. And here, in this bill, Mr. President, we even exclude amateur boxing. In other words, an amateur boxer is not entitled to the benefits, is that correct? He's not entitled to the benefits. Huh? When under the bill, he's entitled to certain benefits like health coverage, like pension, survivorship. So there are benefits that a professional boxer gets, which is denied to the amateur boxer, which to my mind has no basis.
Mr. President.
But the amateur boxing is under the Philippine Sports Commission, so all of that are available to them.
Mr. President, the fact that one activity is under the supervision of one body is not a valid ground to classify the activity as being distinct.
Mr. President, the amateur boxing, there's a law of amateur boxing.
Mr. President, may I add to the discussion?
What's the pleasure of Senator Subiring?
With the permission of just to add to the discussion with Senator Drilon, because I used to, if it's all right with Senator Drilon, I used to be a manager of the Philippine Bukidnon Amateur Boxing Association. I was the representative of ABAP for Bukidnon. When it comes to amateur boxing, Mr. President, there are rules and guidelines given by the Philippine Sports Commission and the NSA, the National Association on Boxing, which is basically the ABAP. That is the Amateur Boxing Association of the Philippines. You're not allowed to give out prize money. You're not allowed, kasi pag may prize money na po, nagiging professional na po siya. It's not anymore under the supervision. It will not be anymore under the supervision of ABAP. They will actually lose their entity as amateurs once they get certain remunerations.
But when they retire, they're no longer engaged in the sport.
If they are champions, we have a law, and part of the law that we passed, which is basically for winners of the SEA Games, Asian Games, and Olympics, we give them, if they are winners, bronze, silver, and gold, they have a particular prize from government, or not prize money, but reward, but they also have a monthly stipend after that. They're given actually a monthly allowance, but they have to be winners of this particular sports events. With professional boxing, Mr. Chair, Mr. President, to Honorable Senator Drilon, the problem is the unregulated boxing matches in the provinces, in Luzon, Visayas, and Mindanao, wherein some of these people are paid only 200, 300 pesos, minsan short-changed pa. It's supposed to be paid 1,000 per fight, binibigyan ng promoter 200 lang. I remember the case of who is that? Luisito Espinosa, who had a boxing match in South Cotabato. He was not paid. The poor guy had to go to court. He was paid after 10 years. And Gab was really not much help to the gentleman. So I understand the plight of Senator Manny Pacquiao, but in this particular case, if the new commission will be focused on the plight of professional boxers, meron silang matatakbuhan po na ahensya that will help them out. And I hope that answered the question, because yung UFC po is a new sport, and I think it's still considered amateur. The ones that are being fought here are still considered amateur fights, the URCC, not the ones in the US. The US, I believe, if I'm not mistaken, the Nevada Boxing Commission, I believe, also regulates the UFC in the United States, if I'm not mistaken. But with amateur sports, Mr. President, it's a whole different ball game. In other words, under NSA's po yan and PSC.
With all due respect to the gentleman from Bukidnon, Mr. President, that is not the issue we are raising. The issue we are raising is that under our Constitution, the equal protection of the law clause, there must be a valid distinction in order to treat a class differently from the others. And what we're saying is that we seriously doubt whether there is a valid classification here in order to be able to defend the bill from on the grounds of constitutionality. That's all that we're saying, Mr. President. If we're willing to suspend our interpretation, and if the sponsor can give us a paper to assert, to defend this particular point, we're willing to do that, Mr. President. So we will not drag the other number of other items in the agenda. We can suspend this first, and then we can. We're willing to get a review and or get an enlightenment from the sponsor on this particular point.
Mr. President, in amateur, Mr. President, there's Republic Act 10699 giving incentives to all amateur athletes, including coaches. It's already a law na nagbibigay ng mga insentibo sa ating mga atleta, sa mga ating mga amateur. So hindi tayo nag-create ng ng bago, kundi ang boxing commission, itong boxing commission ay ang boxing is existing na doon sa Games and Amusement Board, isi-separate lang po natin yung boxing commission. And also yung regulation at saka yung racing horse, yung Philippine Racing Horse Commission, may separate din yon. So what I'm talking about is this Philippine Boxing Commission, hindi ito bago, kundi sinipilit lang natin sa Games and Amusement Board.
That is not the issue, Mr. President. I'm sorry. But we are saying that, what we are saying in fact is that there is no material difference in the risks involved between boxing and professional mixed martial arts as to put professional boxers on its own class. That's the long and short of our position, of our theory. So that is why, if the gentleman sponsor can give us a memo that this bill does not violate this particular provision, then we can accept it.
What's the pleasure of Senator Ejercito?
Just with the permission of the gentleman, as a co-author, boxing is distinct in such a way, Mr. President, that it's a very fatal sport. No? It's a fatal sport.
Fatal?
Yes, it's a deadly sport and it's a dangerous sport that it could be fatal. And there are a lot of boxing, there are a lot of boxers who died after a fight.
So, sir, a professional mixed martial arts match can also be as dangerous.
Yes, Mr. President, but mixed martial arts, UFC in particular, just gained popularity just in the recent years.
That's not material, whether or not one
in the recent years.
gained popularity. What we are talking about are the similarity of the risk involved between boxing and mixed martial arts.
Gentlemen, I hope my interjection earlier would not be misinterpreted. I was not really answering the constitutional objection. I was highlighting the fact that we need to look into professional MMA or contact sports because they may still be unregulated at the current setup, under the current setup.
So,
that's a good point.
Should we regulate them?
That's a good point raised by Senator Drilon in the course of the interpellation. That's a very good point.
Mr. President, it grieves my heart to disagree. Mixed martial arts is not recognized yet. It's not even recognized by POC. Much more IOC. It's completely different from boxing. We cannot compare it with boxing because, for all you know, it can be declared illegal in the future.
Yes, sir, but we're holding matches in the Philippines, so that's why.
Yes, but
who regulates those matches? So I think that's a question that we should ask.
It's unrecognized at the moment, Mr. President.
So unregulated.
So yes, perhaps that is the issue that we should look into. Find a way to regulate that particular sport. But in my case, I will not endorse that sport. It's not even recognized by the International Olympic Committee, Mr. President. It's not a sport. Right? There's no difference between the street fights, illegal street fights, like comparing it to sabog, yung mga tupada. Ganun yun eh. So, I don't dare touch it, Mr. President, at this point. But nevertheless, perhaps Senator Pacquiao may be able to present to the President pro tem an explanation or position that will answer his query. So with the permission of the two gentlemen at this point, may I suspend the session for a while, Mr. President?
Motion to suspend. Is there any objection? There being none, session is suspended.
Professional.
Session is resumed.
We're ready to resume, Mr. President, and we move to suspend consideration considering the fact that Senator Pacquiao will be submitting a proposal that will accept the probable amendment that Senator Drilon is seeking, Mr. President. So I move to suspend consideration of Senate Bill 1306 under Committee Report 31 at this point.
Is there any objection? There being none, we suspend consideration of Senate Bill number 1306.
Thank you, Mr. President. With the permission of the body, I move to resume consideration of Senate Bill 1255 under Committee Report number 12.
Is there any objection? There being none, motion is approved.
Mr. President, this is the measure expanding the coverage of exemptions from revealing the source of information obtained in confidence. And the parliamentary status of the measure is that we are now in the period of interpellation. So may we recognize the sponsor, Chairman of the Committee on Public Information and Mass Media, Senator Grace Poe, and to interpellate Senator Laila de Lima.
Senator Poe as sponsor is recognized. Senator De Lima to interpolate is also recognized.
Good afternoon, Mr. President.
Thank you, Mr. President. Good afternoon to our very esteemed sponsor of the bill. Would the very esteemed sponsor of this measure yield to just a very few questions?
Of course, Mr. President, I'm willing to yield to the senator from Bicol.
I am in full support of this bill, as it is one of those laws that really need to be updated to adjust to the realities of the modern times, particularly advanced communications and internet technology, internet and communications technology. So just very few questions, essentially clarificatory. Does a good sponsor know of any government body or agency that recognizes or accredits members of media? Because I take note of the reality that there is no official accreditation of journalists at present. As long as a person is accredited by a print, broadcast, or internet news media entity, then he or she will be covered by the privilege when circumstances warrant under this proposed bill. And we note that during the public hearing held for this bill, the response, I think, of Senator Soto is that if a news outfit is legitimate, then it must be registered in the SEC or some other organization like the National Press Club or the Philippine Press Institute. But there seems to be no government body or agency that would accredit members. Is that correct?
Yes, Mr. President, you are correct. There's no official government agency that accredits journalists. However, there are private organizations like the National Union of Journalists of the Philippines, the Philippine Press Club, and the Publishers Association of the Philippines, and many others that may have their own registrations with the SEC.
And based on our research, Mr. President, esteemed colleague, there was a bill filed by former Senator Jinggoy Estrada during the 16th Congress. This is supposed to be the Magna Carta for journalists that seeks to create the Philippine Council for Journalists, mandated to accredit journalists and produce a database or directory of accredited journalists from both print and broadcast media. And I think this bill also institutes a licensure examination for journalists. My question is the good sponsor open to considering a similar bill, perhaps a separate bill, separate from the Soto or Shield law?
Yes, Mr. President, we are just being careful and towing the line also because we want to make sure that our journalists maintain their freedom and their independence. But if the bill is filed, we can certainly ascertain the advantages of that for the protection also of the journalists. I mean, they may not necessarily be compelled to register, but the government can offer them certain recognition so that they will have protections also under the law.
Thank you, Mr. President. I just wish to be clarified, Madam Sponsor, as to whether blogs or bloggers are indeed covered in the bill.
Yes, if the blog or the blogger in the blog is a part of an organization that's recognized, for example, that's big enough, like the NUJP, as I mentioned, or the Philippine Press Association, or even the Publishers Association. Well, they're identifiable persons.
Even by their audience.
And if they're recognized as journalists even by their audience. I mean, part of this also is their free speech, to be able to say what you have to say. But as you know, we had to amend this bill to include not just print, but television, as well as television and internet, because of the technology change. So now, blogs are actually part of the forum where journalists freely say what they need to say or report.
And still in relation to that, Madam Sponsor, is the proposed measure, well, you just mentioned that blogs and bloggers are covered by this bill, and I think during the discussion in the course of the committee hearings, that was the consensus, that writers of blogs can be considered, or may be covered, as they may be considered as a journalist or writers of opinion, or writer of news for mass circulation through the internet, as long as they represent a legitimate media entity such as Rappler.
Yes, actually, Mr. President, I'd also like to bring up the case with regards to Emil Horado, and the Supreme Court held that RA 53 confers no immunity from prosecution for libel or for other sanction under law. It only gives the journalist the right to refuse to reveal any source related in confidence. So they have the right to refuse related to them in confidence, but if it's libelous, they're still not immune from suit.
It's still the very context, actually, of the Soto or Shield law.
Absolutely.
But I think insofar as blogs and bloggers are concerned, especially those that do not seem to represent or be part of a legitimate entity, I think we should have stricter supervision.
Yes.
And regulation.
Yes, I agree, Mr. President.
There are blogs with high online traffic which are not actually recognized or accredited by a legitimate news media entity. Bloggers like the Mocha Uson, published via Facebook, but don't get me wrong. I don't read the Mocha Uson blog. Gawa lang po ito ng staff ko. So is she covered by the Shield law? And other bloggers like Joe America, Raisa, Robles. So while I see the point that this measure or the proposed amendments to the Shield or Soto bill would or should cover also blogs and bloggers, there ought to be some special provisions in relation to them for stricter regulation.
Yes, actually, Mr. President, the point of the law is to protect the source. If they cannot present their source, then they have to prove the truthfulness of their statements. Sometimes the source will give you the lead, but it is really up to you to point to the facts that will legitimize the information you receive from a source. Now, I also agree that we need to be able to weed out the irresponsible ones and the ones that are malicious. And so perhaps during the period of amendment, we can narrow down all of these safeguards and include it in the provision, because again, we have to toe the line and we have to be very careful that we don't stifle freedom of expression, but we also have to uphold responsibility among writers, be they bloggers, especially when they are assassinating the character of a person, if it's not truthful. So, yes, we will take this into account in the period of amendment, Mr. President.
And certainly fake news are not covered.
Yes, and
news
we're
as
going to
fake
have a
news.
hearing on that, Mr. President, because, that's precisely the point. I mean, you're a journalist. You have to uphold a certain standard. If you're just rumor mongering, then that's not really, I don't think it should be considered part of this bill.
Thank you, Mr. President. That would be all. Thank you to the distinguished
Before we
sponsor.
move on, the Chair would like to interject, Madam Sponsor. In this day and age of social media, I hope that social media practitioners have no accountability. I hope that you'll take that into consideration in your amendments as compared to the mainstream media, which have, at least they have their accountability.
I know they have, yes, Mr. President, you're right. At least the mainstream media that actually has a reputation to uphold files the necessary permits and taxes, so therefore they have certain responsibility. Is our source for reliable media now? I mean, but not they don't have a monopoly of that either. But to a degree, there will be some sort of accreditation which shall be affected by the media outlets and practitioners themselves. It's almost like a self-regulation, Mr. President. I think that they have to be able to police their ranks, to be able also to enjoy some sort of a protection under the law. The media has been effective in regulating themselves, maybe not as much as we would want them to be, but at least they should be encouraged towards that. They have also actively campaigned against fake news, because such belittles and mocks the effort and time a journalist spends vetting his or her sources. We should also note that fake news sites usually just aggregate content from legitimate news sites and distort the content to propagate information that will either fit their political agenda or spread misinformation. Thus, they usually have no sources to protect.
All right. Thank you, Mr. President. Mr. President, we will allow our colleagues to prepare for the period of amendments. So in the meantime, I move to end the period of interpellation, Mr. President.
Are there any objection? Hearing none, period of interpellation for committee report number 12, Senate Bill number 1255, is hereby approved.
Move to suspend consideration of Senate Bill 1255 under committee report number 12.
Committee report number 12, Senate Bill number 1255 is hereby suspended.
Thank you, Mr. President. Mr. President, I move to resume consideration of Senate Bill number 1233 under committee report number 8.
Committee report number 8, Senate Bill number 1233, is up for interpellation. Senator Pangilinan.
Mr. President, this is the measure creating the Coconut Farmers and Industry Trust Fund. The parliamentary status is that we are in the period of interpellation. So yes, we will move to recognize the sponsor, Chairman of the Committee on Agriculture and Food, Senator Francis Pangilinan, and to interpellate the Minority Leader, Senator Ralph Recto, and thereafter Senator Gordon, Mr. President.
Senator Pangilinan is recognized, and also our Minority Leader, Senator Ralph Recto.
Thank you. Thank you, Mr. President. Would the distinguished gentleman, Chairman of the Committee on Agriculture, yield to a few questions? Willingly, to the gentleman from Batangas and Quezon. Thank you, Mr. President. Some preliminary questions before I go to the meat of the matter, Mr. President. The title of the bill is Creating the Coconut Farmers and Industry Trust Fund.
That is correct.
Among others, no? Now, how many trust funds does the national government have, Mr. President?
Well, similar to this trust fund being proposed, Mr. President, our research tells us that there is nothing similar to this type of trust fund that we are proposing that would benefit the coconut farmers and the industry, and used to be to develop the coconut industry.
Mr. President, the question is, how many trust funds does the national government administer? Not whether it is similar. Marami bang trust fund ang national government? How many are there?
May we have? I think the former NEDA secretary would also have some information regarding this, but we will try to get the information, Mr. President. May we have a minute suspension? Session suspended. Ready to resume, Mr. President. Session resumed. Yes, Mr. President, we don't have the exact figures, but just for the record, you do have, for example, the GSIS as a trust fund, the SSS as a trust fund, government trust fund. You have the Overseas Workers Welfare Fund as a trust fund, Pag-ibig is a trust fund. So there are several government trust funds, Mr. President.
How many are administered by the Bureau of Treasury? Because under this bill, this will be under the Bureau of Treasury.
Well, the Bureau of the Treasury has relayed to us that they have 10 trust funds that they are administering.
10 trust funds, okay. Are there different types and natures of trust funds being administered by the Treasury Department?
Well, we don't have the information now, but I assume that if the number is correct, 10 trust funds, and that would be different trust funds. Mr.
All
President.
different.
But we can provide the good gentleman the information.
Are all of them earning money?
Yes, my understanding, Mr. President, is that they are earning money.
The Malampaya Trust Fund, does that earn money, Mr. President?
The Malampaya Fund, as I understand it, Mr. President, is not in the nature of a trust fund, but it is a special account in the general fund, SAGF.
But it is a trust fund. But it is in a special account. So maraming klaseng trust fund. Yes. Some are earning and some are not earning.
That is correct, Mr. President.
Some are commingled as well. With
That is correct, Mr.
budget. Okay. Now, are there any other government agencies aside from the GOCCs administering trust funds?
that we are aware of, Mr. President, but again, we can double-check the information and provide the good Senator.
All the information will be available with the Department of Finance and the Bureau of Treasury. Is that correct?
That is correct, Mr. President.
Were they consulted during the committee deliberations?
Yes, they were, Mr. President. In fact,
The treasurer was present during the committee deliberations?
the treasurer was present. What's his name? Yes, Mr. Roberto Tan, our national treasurer.
Yes. What about the Secretary of Finance? Was he present during the committee deliberations?
The representative. During the hearing, Mr. President, there was a representative, not the secretary himself was not present.
Yes. Okay. Now,
But their position, the secretary,
this bill is also, to a certain degree, like an appropriation measure. Is that correct?
well, it is not an appropriation measure in the sense that there is an existing law that provides for the appropriation, actually the use of the COCO levy funds. That would be PD 1234. Therefore, this fund has already been, this fund it can actually be, technically without the restraining order, it can be disposed of or appropriated or spent or disbursed because of existing law.
Okay, but there is a TRO.
That is correct.
And what are we doing in this bill, Mr. President? In effect?
Right now, the fund, the cash component of the fund, which is around 76 billion.
Who says it is 76 billion, Mr. President?
The Treasury. The Treasury.
Is there a certification from the Treasury?
Yes, in fact, a representative of the Treasury was here yesterday and gave us the latest certification and documentation.
And what does it say? That there is 76 billion available?
Yes, there are two documents here. Status of the PCGG escrow account on government securities transferred by UCPB, and this is 13 billion. And there is another document here, status of SAGF for COCO levies, and the total here is 62.5 billion.
Okay. So 62 plus 13, so roughly 75.
75.5.
And is that a certification of the Treasury saying that we have 76 billion in the bank? Is there available cash, Mr. President?
13 is cash and bonds.
Yes, the 13 billion is cash and bonds, and the 62.5 billion.
13 billion cash in bonds, liquid yan. Available yan.
Yes, that is correct.
Okay.
And the 62.5 billion is SAGF, which is commingled with the general fund.
And what does commingled mean?
It means that
There is no cash.
no, there could be cash, or that the cash is actually allocated.
There is no separate account that says that there is 62 billion in this particular account earning interest, halimbawa.
That is correct.
that
The
correct?
SAGF, the SAGF, the fund allocated as a special account can actually be, because it's commingled, can actually be currently invested, except that the interest of such investment does not accrue to the fund itself.
So right now, that is unearning. To be
That is
clear.
correct.
And it's commingled.
That is correct.
So there is no actual special account with the Treasury except for an accounting record in that document.
That is
It's just an accounting record in that,
That is correct.
document.
That is correct.
Hindi kumikita ng income yan.
Hindi kumikita ng income para na ibinabalik dun sa COCO levy.
Is there a certification from the Treasury Department saying that we have 75 billion cash available that we can transfer to what you intend to create, a Coconut Farmers and Industry Trust Fund. An actual certification.
That actual certification is not available.
not.
However, the Treasury representative informed us that once a notice of cash allocation is issued, I mean, with the corresponding...
Shouldn't we have that document first when we discuss, while we are discussing the bill, na maliwanag meron tayong ganitong halaga to talk about?
Well, that's precisely why we need this bill, so that we can transfer the 62 billion from the special account to a trust.
No, I have no problem with passing a measure. What I'm saying is that normally, when we appropriate, the Treasury tells us we have these funds available. Hindi ba dapat they tell us that there's an official, yes, we can transfer this to a trust fund that we intend to create. Itong halagang ito.
May we have a minute suspension, Mr. President? I would like to approach our colleague.
Session suspended.
Mr. President.
Session resumed.
Yes, sir. Thank you, Mr. President. At the appropriate time, maybe in the succeeding interpolations, let us already warn the Bureau of Treasury that they should issue a certification of some sort, that there is an available fund, the 75 billion ready for us to put in a trust fund. Kasi kung wala naman, what are we talking about here? Diba?
I understand, Mr. President. Mr. President, what we will request...
And I want to ensure that the farmers' money is available. Na hindi dapat kino-commingle yan in the general fund. There is a specific purpose supposed to be, di ba?
Yes, we agree, Mr. President. And what we are proposing now is that we will request the Treasury to provide us a formal written communication with respect to these two documents that they have provided us.
Okay, thank you for that, Mr. President. Mr. President, could the gentleman, the chairman of the committee, give us a brief history of the Coco Levy Fund? When was this created and why was this created?
May I have a minute suspension, Mr. President?
Session suspended.
Okay lang. I can.
Nasa ba yung... Kita mo ngayon. Hindi, nasaan yung... Punto na lang after nito. Kasi wala siya. TV
Ready to resume, Mr. President.
Session resumed.
Yes, Mr. President, the document that I am reading from is a submission of the Presidential Commission on Good Government. The coconut levy was established in 1971 and whose purpose was to expand the coconut industry, which was considered as one of the major components of national development. The goal of imposing the coco levy then was to establish and maintain a strong and viable coconut industry. So that was 1971. Also in 1971...
In 1971, this is a Republic Act.
That is correct.
6260, which establishes first the Coco Levy Fund.
That is correct. The levy is
Here we are
collected...
today, 2017, wanting to put up again a Coco Levy Fund.
That is correct, Mr. President, except that that Coco Levy Fund that was established in 1971, after which the Philippine Coconut Authority was created to administer that fund. That is precisely why there were some concerns raised during the...
In fact, the Philippine Coconut Authority was established even earlier than what you mentioned, right?
Yes.
Earlier. So, in this bill, our version of the Philippine Coconut Authority will be the committee.
That is correct, Mr. President. And the Philippine Coconut Authority will be part of that committee.
Correct. So, therefore, it is similar to what Marcos did in the 70s.
Well, in theory, Mr. President,
We're establishing a Coco Levy Fund again,
in theory,
all over again.
but the proceeds of the levy, Mr. President, is what we are, what we are, hope to be able to disburse.
Correct.
But there is no levy that is being exacted.
Again, for the benefit of the farmers.
That is correct.
Nakinabang ba yung mga farmers when we put up this Coco Levy in 71 until today?
Well, Mr. President, like I said in my sponsorship speech, they continue to be the poorest of our farmers.
And they, in the past, they were not the poorest.
That is correct.
And now they are the poorest.
That is correct, Mr. President.
And we're doing the same thing all over again.
That is where we'd like to believe, Mr. President, that we are ensuring that the lessons of the past will not be repeated, that safeguards are being provided for in the measure, that we would like to avoid a misutilization of the fund, Mr. President, and that precisely, finally, that it will redound to the benefit of the coconut farmers and the development of the industry.
Okay. So Republic Act 6260 developed the Coco Levy Fund. How did it, where will the money come from, Mr. President? Is it in Republic Act 6260 also?
I'm sorry, may the question be repeated?
So, again, what is Republic Act 6260?
6260 imposed the first levy on coconut farmers. The levies collected from the coconut farmers, for which they were issued cocoa fund receipts to be converted into shares of stock.
Okay.
And this fund was used primarily to establish the Coconut Investment Fund and the Coconut Investment Company.
Okay, and how much was collected?
Well, we don't have the data initially, but from 1972 to 1982, a total of 9.6 billion was collected.
Pero maraming funds yan, di ba?
Yes.
Hindi lang naman isang fund yan eh.
That is correct, Mr. President.
Okay. Could we have a breakdown of how much was collected per fund?
We will try to retrieve that breakdown from 1971 until today, Mr. President.
You have the total, 9.7 billion.
Yes, Mr.
correct?
President.
Because
9.69 billion. yes.
Because this is material we're saying here that all these funds, all the money collected from all these funds be transferred now to this new trust fund that we're creating. Is that correct?
Yes, that is correct.
Yeah, so we have to make an accounting of all these funds.
Well, Mr. President, precisely part of the provisions of the law of the proposed bill is to have an inventory and an accounting.
Correct.
So we do have I'd like to think preliminary figures based on the submissions of the PCGG, the UCPB, but I think a more thorough inventory and accounting has to be undertaken, Mr. President.
Yes. We will get to that. But at the moment, as far as Congress is concerned, or here in the Senate, dapat alam din natin more or less what we're talking about here. Magkano ba talaga na-kolekta from the farmers to begin with, di ba? So ito, farmers pa lang to, di ba?
Mr. President, again, from the document of the PCGG.
Yung Republic Act 6260 from the farmers.
Yes.
How did they collect it from the farmers, Mr. President?
For every kilo that the farmers sold, there was a 6260 says, Section 8, there shall be levied on the coconut farmer a sum equivalent to 55 centavos on the first domestic sale of every 100 kilos of copra, or its equivalent in terms of other products.
Correct. Okay, so, paano nila kinolekta? Who collected the money?
PhilCoA, the Philippine Coconut Authority, shall collect the levy and immediately thereafter deposit the proceeds in an interesting earning account. So, the
So the
PCA...
COA collected the money from the farmer or they collected it from an intermediary?
My understanding, Mr. President, is that there may have been intermediaries based on the consultations that we did.
So, posible from the miller.
Maaring from the miller.
Benta ng farmer.
That is right.
Let's try to find out. That's my point.
Yes.
Okay?
Yes.
Para malaman natin who contributed to the fund.
Yes, we will do that, Mr. President.
Okay. And then you mentioned shares of stock.
That is correct.
Right? In exchange for the contribution.
That is correct, Mr. President.
Okay. Who issued those shares of stock?
PCA, Mr. President, issued Coco Fund receipts
Yung resibo, pinalit for shares of stock.
to be converted into shares of stock.
Who converted the receipts to shares of stock?
Well, we will have to find out, Mr. President. I am assuming it would also be the PCA in coordination with the Coconut Investment Company.
Do we still have a copy of those shares of stock? Are they still available?
Mr. President, when we were going through our consultations, some farmers actually showed us copies of their shares of stock or the receipts, Mr. President.
Okay. Let me jump a while, right? Okay, so kung 9.7 billion yung nakolekta, how much is it right now? Yung 9.7 yan, magkano na ngayon yan?
Well, Mr. President, right now, they are both cash and assets because a portion of the
The cash today is 13 billion and commingled is 62. Okay.
and then you have
Other assets.
oil mills.
Yeah. Marami naman yun. All of that. The oil mills.
The oil mills, of course, UCPB,
Yeah, all of that.
and Coco Life.
How much is the value of all of that?
Well, these are estimates, Mr. President, but For example, Coco Life, which is a insurance company, 8.4 billion. UCPB shares at PMO estimate 74.9% is 3.5 billion. The oil mills would be 6.6 billion. And then there are still cases in the Supreme Court. 4% SMC Treasury shares still pending. It has not been decided with finality, but the estimate there is if it's at 25.5 million shares, that would be 2.1 billion. But at 127,000 shares due to dividends, that would be 10 billion. So 10 plus 2 plus 8, that's 20, plus another 10, 30, plus another 2, 35, plus 75, over 100 billion cash and assets, Mr. President.
Over. Much over than 100 billion.
Well, I would say over 100 billion.
Over 100 billion. So from 9.7 to 100 billion.
That is correct.
Magandang investment ba?
Hindi lang nagamit.
Ha? So ano yung ROI nun from 9.7 to today of 100?
Oh, 1982. So 82 to 2012 is 40 years. Tama? Oh, 82, 92,
30 years.
30 years.
30 from
9 billion to over 100 billion.
Yeah. Huh? 45 years. So maybe you can give us a computation ROI nun, di ba? Now, lumaki yung fund. Kumita naman. It would appear. Nakinabang ba yung farmer?
Well, if we are to base it on their quality of life today, hindi ho.
At bakit hindi kumita? Bakit hindi nakinabang ang farmer? Kasi all that money hindi naman nagastos din for the farmer, is that correct?
That is correct. And precise, yes.
Now that's similar also in this measure, because here kung interest income lang, hindi rin makikinabang ang farmer.
Well, the objective, actually, part of the policy direction is that precisely there has to be a roadmap or a plan so that there will be cocoa.
I'm not talking about that yet. I'm just talking about in the bill, perpetual to, of course, the first 2 years, 10%. But then it's just the interest income ang mapupunta sa farmer. If you add inflation pa,
yes,
halos wala. So pag maaring, even if they invest it in high-yielding instruments,
yes,
pero kung puro dun lang napunta, lalaki yung pondo, hindi rin makikinabang ang farmer. Kasi you're limiting it under the bill to only interest earned, perpetual yung fund, habang buhay.
That is correct, Mr. President. Mr. President, during the consultations and the committee hearing, there are actually two schools of thought. One school of thought is that it be a perpetual fund. The other school of thought is that there has to be a significant use of the principal, not just the interest, so that there will be a direct impact on the coconut industry. We sort of came up with a hybrid compromise. We will use part of the principal, after which the balance would be in perpetuity, of which only the interest income will be utilized. Mr. President, if I may also place on record, the reason why there is this
could you submit to the minority how much do you expect to spend under this proposal in the next 6 years?
We will do that.
Okay, so let's move on. Then
But just to place it on record, Mr. President, if I may be allowed, I can understand fully the philosophy that if we only use the interest income hirap na yung mga magsasaka. Hindi na ho sila, marami sa kanila na unang napatawan ng levy ay may sakit na o kaya sumakabilang buhay na at hindi man lang natikman itong pondong ito. Kaya ang panawagan is gamitin yan. Diba? Use the fund so that there will be an impact.
That will be the nature of my amendments, Mr. President.
Yes, but just to complete this, the point being raised, Mr. President. But sadly, the experience of the country in terms of agriculture funds being appropriated in lump sums in the last perhaps 15, 20 years, or maybe in the last 7 years, has not been good. You have the fertilizer scam. You have the Napoles bogus agri fund, farmers organizations fund. You have the ASEF fund. The ASEF fund until 2010, 8.5 billion. So we cannot blame or fault perhaps the stakeholders of the coconut farmers and the coconut industry sector, if they are hesitant to allow a huge appropriation at the onset, precisely because the track record of government in utilizing this
But the track record also of the cocoa levy, from 9.7 billion to more than 100 billion, wala ni isang pisong ginastos for the coconut farmer. So yung mga binigyan ng resibo, binigyan ng shares of stock, buhay pa ba sila hanggang ngayon?
Merong mga buhay pa ho, pero
Ilan ba yung nagbayad, ilan pa ang buhay pa, ilan yung nakinabang?
well, we don't have that data now, but we can probably try to piece it together. But suffice it to say, Mr. President, when the Supreme Court ruled in 2012, part of the decision said that the levy is in the form of a tax, and therefore it belongs to the government, but it must be utilized for the benefit of the coconut farmers and the development.
And that is the decision of the Supreme Court, because that is in the PD. Isn't that correct? Yes.
We will have to check that, Mr. President.
Yes, yun yung purpose. Kaya nga ginawa ni Marcos to, supposedly, in the name of for the benefit of the cocoa farmers, we will collect a tax from them, ibabalik natin sa kanila. So tama lang naman. A tax is public. Yes. So ari ng gobyerno to, yun sabi ng Supreme Court, but since walang bagong batas tungkol dyan, ari ng gobyerno to, pwede mong gastusin lang for the coconut farmers unless Congress makes a new law. Halimbawa, yung Malampaya Fund, yun din ang decision ng Supreme Court Pwedeng gastusin lang for energy development and exploration.
And the development of the coconut industry.
Hindi, yung sa Malampaya Fund naman, for energy related.
Yes. That is correct.
Because that's part of the PD as well. Okay. Okay, and then 2 years after that, June 1973. So 71 basically from the farmer. Yes. But it may not have been collected from the farmer, or although through an intermediary, maybe the miller. Incidentally pala, all these taxes, who will pay this at the end? In this case, binigyan ng resibo yung farmer. Tama.
That is correct.
Okay, but who pays for it at the end?
Well, my understanding, Mr. President, is that it's the farmer himself. From every 100 kilograms,
correct,
they would slash 55 centavos.
Correct.
Yes.
Okay, but itataas din naman yung presyo, magbabayad din yung consumer. Di ba?
Well, yes, in that formulation, yes.
Di ba? Is that correct? Okay, so let's move on. And then 2 years down the road, 1973, what happened?
Well, in 1973, June, President Marcos created the Philippine Coconut Authority through PD 232.
Okay, so let's stop there for a minute. So here, we're doing the same thing, creating a trust fund for the benefit of the coconut farmer. And then in 73, President Marcos said, let's create the administrator, the authority, the Philippine Coconut Authority.
Yes.
Dito naman, in the bill, we're creating a committee.
A committee under the office of the president. In other words, the difference being that it is now lodged at the highest level.
Well, during that time, it was also under the office of the president.
No, but the committee, the PCA will now be subsumed or will now be a part of or a representative
saying that, organizationally, it is the same. We are copying, to a certain degree, many of the ideas then of President Marcos.
Like I said, Mr. President, in theory, yes.
Okay, thank you for that, Mr. President. So what else did the PD 230 do? Aside from the establishment.
Well, it consolidated the responsibilities and activities of the Coconut Coordinating Council, the Philippine Coconut Administration, which was the PhilCoA.
Now there, may mga private sector representatives din yan.
Well, this document does not say, Mr. President, but I think the Coconut Coordinating Council should. We will double check, but that particular council should have private sector representatives.
Nandiyan na yung mga Philippine Coconut Federation, so on and so forth, di ba?
Yes.
Okay. Now, weren't there additional tariffs also in the PD?
I think the tariffs were eventually adjusted.
Isn't it dito naman may export tariff na? That's how this export tariff.
We will have to check that, Mr. President.
Because not all of these were collected from the farmer. Some were collected from the miller, from the exporter, so on and so forth. Is that correct? From the industry.
Yes, Mr.
In
President.
fact, your bill mentions that.
That is correct, Mr. President.
In fact, it will be
up to today, Mr. President, the Philippine Coconut Authority still collects certain fees and certain from the
because
millers.
of the PD.
Yes.
Which those figures have never been adjusted.
Yes.
So parang today, may coco levy pa rin to a certain degree.
Well, we wouldn't call it a levy, Mr. President. They collect fees.
Where does their authority come from to collect these fees?
From the law, Mr. President.
What law?
PD, a series of PDs, Mr. President.
Correct. So it's part of the coco levy. Hindi lang na-adjust yung rates. Maliliit na ngayon yun dahil 70s pa to eh.
Yes, Mr. President.
Diba? Okay. So, and then you have what happened a month after that.
That would be a month after June is July.
2 months. August 1973.
Well, yes. August 1973, PD 276, establishing the Coconut Consumer Stabilization Fund.
So that's another fund again.
Yes. It aimed to implement an industry finance stabilization scheme which will permit socialized pricing, Mr. President, of coconut-based commodities.
So what was the purpose of the stabilization fund?
To mitigate the impact of the oil crisis. This is what I guess that was the oil shock of 1973.
And
it aimed to implement an industry finance. Yes, I said
an additional levy.
a levy initially of 15 pesos per 100 kilograms of copra.
And that is collected from whom naman? From the farmer or the
Shall be
miller?
imposed on every first sale. So that's the farmer selling it to the miller.
Or is it the miller?
Well, for every first sale.
So could we find out from the...
Yes. We will.
Can
me note that.
Okay. So that's another fund, huh? Okay. And then, could we also know how much was collected through Republic Act 230 and then now 232 and then 276?
We will endeavor to
get that.
to get the information, Mr. President.
Okay, sige. And then, what
I would like
happens
to
next?
think, or I hope that would be in the breakdown of the 9.6 billion.
Yeah. Okay. And then, you have a year after,
1974, 75.
74.
What is 74? Ano yung 74?
EO425.
EO425. We don't have it here, Mr. President, but do you have it? May we have a minute suspension, Mr. President? Session suspended.
So, ito investment. Dito nag-umpisa yung mga holding company.
'Meron kayong kopya?
resume, Mr. President.
Session resumed.
Mr. President, after conferring with the minority leader, we have agreed, Mr. President, that we are to suspend consideration of this measure, suspend the period of interpellation, and we will resume interpellation on Monday, Mr. President. So, with the permission of the majority leader, Mr. President, I move that we suspend consideration of this measure.
Is there any objection? Consideration of committee report number 8 on Senate Bill number 33 is hereby suspended.
And we'd like to thank the minority leader for his interpellation and majority leader for scheduling it today and again on Monday. Thank you, Mr. President.
Yes, we will schedule it right after the corporation code, which gave way today to be able to, for us to be able to accommodate the coconut levy bill. Yes, thank you, Mr. President. Mr. President, may I move that Senator Sani Angara be replaced by Senator J.B. Ercito in the membership and chair of the Committee on Local Government in the Commission on Appointments, Mr. President. So moved, Mr. President.
Is there any objection? Hearing none, the motion is hereby carried.
Upon the request of Senator Pacquiao and with the consent of the body, Mr. President, may I move that the following senators be made co-authors of Senate Bill 1306 or the Philippine Boxing Commission Act: Pimentel, Soto, Subiri, Gordon, and Villanueva. So moved, Mr. President.
Is there any objection? Hearing none, motion is hereby carried.
Upon the request of Senator Risa Ontiveros and after getting the approval of the principal author, I move that Senator Ontiveros be made co-author of Senate Bill 177 or the Free Higher Education Act, Mr. President.
Is there any objection? Hearing none, motion is hereby carried.
Mr. President, I move that we adjourn the session until 3 o'clock in the afternoon of Monday, February 6, 2017.
Is there any objection? Hearing none, the session is adjourned until 3 o'clock in the afternoon of Monday, February 6, 2017.